So my partner and I are getting a divorce. We've already talked about everything. We've split everything. Do I have to have him formally served?
That's a really great question, Alex. No, if you have an amicable divorce and neither one of you thinks you're going to fight about a whole lot, instead of having your partner served, you can have him sign what's called a waiver of service.
What's a waiver of service?
Another great question. Waiver of service has multiple components. At its base, a waiver of service is essentially a document that your partner will sign in front of a notary that fundamentally waives their right to be served by a process server. What does that mean? In the average case, when you file a lawsuit, regardless of whether it's in a family law case or a civil suit, you have to serve the other party with notice of the fact that a suit has been filed. In a case that is more amicable, you would instead have your partner sign the waiver of service, which is them saying, hey, it's okay, I don't need to be served by a process server. Instead, here's a document in which I say, this is my name, this is my date of birth, these are the last 3 numbers of my social security number. I formally waive the right to be served by a process server. And instead, I am here informing the court of my presence and my appearance in this lawsuit. And to the extent that hearings are held or any documents are filed, I would like to be served with those documents. So typically the waiver of service would also include a space for your partner to include their email address to have that on record with the court. And at that point, then your partner has formally made an appearance into the case. So the case can proceed as though your partner had been formally served.
Okay, so he signed the waiver of service. We've gotten it back to you. Now what?
As long as he's signed in front of a notary, you can then go ahead and file the waiver of service with the court. What that does is that kicks off the 20-day period before initial disclosures need to be served. And for more information on initial disclosures, you can watch one of the other fabulous videos recorded here at Varghese Summersett on that topic.
Okay, so the waiver of service has been signed, it's returned to you, it's filed with the court. Do we schedule mediation? Do we start talking about a final divorce decree? What happens?
You can really go one of a few ways here, depending on how exactly your relationship with your partner is, what your specific concerns are with your divorce, and if you're worried at all about bindingness or finality. So in many cases where we have amicable divorces and both parties are on the same page, perhaps there are not that many assets to divide, or perhaps there are no children involved, or if there are assets and there are children, you and your partner agree on what to do with those kiddos and how to divide those assets. So in a case like that, it's really easy for our office to draw up a proposed final decree that contains all of the terms that you and your partner have already discussed regarding disposition of assets and or how you and your partner are going to split your rights and duties and possession and access of your children. In the event that you maybe have a few outstanding issues, maybe there are a couple of things that you don't necessarily agree on, or in the event that you're just concerned that we'll work out an agreement, we'll have it in writing, and then all of a sudden at the 11th hour, your partner will decide, hey, I changed my mind. I don't want to sign this. I don't want to proceed with this divorce, or I don't agree with everything. Then mediation is a fabulous tool. And in that case, we would get mediation scheduled with one of the many incredible mediators that we use here in Tarrant and the surrounding counties. And the great thing about mediation is it's if you settle, binding and irrevocable. So you get past all of those fears about perhaps having an agreement and then having your partner renege on or back out of that agreement.
Okay, I think that all makes sense. So if my partner does decide to sign the waiver of service, does that mean they can't retain an attorney?
No. At any point during the divorce process, your partner can decide perhaps things have gotten a little bit more complicated than they thought they might be, or perhaps they've changed their mind and they do want to retain counsel. Filing a waiver of service in no way waives your right to retain an attorney should you wish to do so at a later point in the divorce process.
So to that point, if things do get more complicated and I can't get my partner to sign the waiver of service, what happens then?
We see this fairly frequently. A lot of times divorces start off and it seems like everything is going to be really great and agreed on and hunky-dory and everybody's on the same page. And then a conflict occurs or somebody thinks twice about waiving their right to service, which again is not a waiver of your right to participate in the legal process. It is honestly just saying, hey, please process server, don't come serve at me at my place of work, don't come to my house. If you start off wanting to do a waiver of service, and then your partner decides, I changed my mind. In that case, then we would have to move forward with having your partner served, because unfortunately, without some sort of record or acknowledgement to the court that your partner is officially aware of the divorce process or the SAPSR process, then there is the only option there left is to have them served.
I got nothing left.
And that is waivers of service. Thanks for watching. If you have any questions or comments, you can leave them down below.
Otherwise, you can find more information at familytexas.com.